So if you are going to make any mistake, there is going to be a liability that's going to bound on you. Expert is a person who knows about the company, who knows about the situation, who knows about all the factors that are governing them. Information is something that comes to you in the regular walk of life on a constant basis from every part of this world. Now, every person who's involved in this activity will definitely be questioned by the government. Good morning and welcome to the session 4 of Unit 3 in Company Law, where we are going to speak about the liabilities that are arising out of a misstatement. Now, is it true that there can be a liability coming out just out of a statement? Is it possible? Now, that's a question which anybody would like to ask, but the answer to that is an yes. Why? Because if you are going to make any wrong statement or comment about the company, that is going to be questioned altogether. So let's just move forward and try to understand what are the possibilities and chances of landing up on a penalty. Now, the introduction part here is like this, where we are trying to talk about any untrue statement in the prospectus that raises to two kinds of liabilities, civil and criminal liability. It's a very, very important factor. Now, the concept of liability has to be clearly understood here. When I use the word liability, which means to say that there is some problem for which I need to pay. This is not about a loan or some kind of, an external borrowing which I have done. But this is something where you are responsible to the society, to the investors, and to the people who have trusted on you and invested in the company. So if you are going to make any mistake, there is going to be a liability that's going to bound on you. Now, for example, let's say that when you look into companies like DHFL, the Diwan Housing Finance Limited, when the company was doing extremely well in terms of the share price, in terms of its operation, people believed the potentiality of the company so much that they always wanted this company to be the number one in the market in terms of the home finance business. And similarly, if I have to give you the example of a company named ILFS, which was primarily involved into infrastructure leasing and financial services. This company was doing extremely well when all of a sudden when this company had to shut down because of its wrong turn in the operations, and similarly when DHFL was also closed down because of the problem in terms of the finance. Now, what is happening here is that, let's say for an example, if a company like this had gone in for an IPO and where they had mentioned certain things which are not true to its nature. So I go ahead and I just mentioned stating that I had made profits in the last 5 years, 10 years, 20 years and all those factors, and I give a very, very rosy picture about my entire development, about my entire growth aspect altogether. Now, what is going to happen is the investor is definitely going to make a note of it. The SEBI is going to make a note of it. The exchanges are going to make a note of it. Everybody will be behind me. Now, tomorrow, on a whistleblowing session, somebody just goes ahead and raises the siren saying that this company went ahead and cheated people by giving out the wrong information. I am bound to be doomed. Why? Because this is where the prospectus issue becomes a very, very serious affair. Because in the prospectus, as I have told you earlier, if you are going to mention a statement which is not true in nature, which is not clearly mentioned in nature altogether, that means this is going to lead into a definitive problem altogether. This is definitely going to go against the system, against the factors altogether. So it is very, very important for all of us here to understand that yes, if we are going to land ourselves into a problem, into a situation here, this is going to come in terms of a very big liability for us. Now, that liability is again of two kinds. It might be a liability where we are just going to pay the penalty and come out. That means it might be something related only to the fine factor. Or else, if it is going to be a serious liability leading the company to go behind bars, that means the people who are involved in that going to go behind the bars, which will come into a criminal liability altogether. So the question here is that, are you ready to take a risk like that and put your company and your members into a severe situation that can probably bring down the future of the company itself? So that's why we say that before a statement is being published, it is being talked about and it is being told in the market clearly. Let us understand the contents. Let's understand each and every line before we start printing it. Now, going forward, let's also talk about the civil liability first in terms of misstatement. No person shall be liable for the compensation of loss or damage if he says he withdrew his consent to become the director before the issue of the prospectus. Now let's go point by point here. Now, I am being a director of a company. Before the prospectus, that is before the launch of the prospectus asking for a new capital is being done, and I withdrew from the company saying that, sir, I didn't want to continue because of so and so reasons, then automatically I am not liable, because I have raised up my hands before itself stating very, very clearly, sir, I am not the person concerned. I don't want to continue with this system because I am slightly skeptical about their operation, slightly skeptical about the way they are performing. So I have given up even before saying that, sir, I am not the person who is involved in this business. That means to say that, yes, you are right, sir. You are not the concerned person. You are not liable for anything. Now, the prospectus that was issued without his knowledge. Now, the second factor, knowledge and information. Let me just talk about this for a while so that you will be able to understand better. Knowledge is something which is inherent by nature. That means you have gathered it over a period of time. Information is something that comes to you in a regular walk of life on a constant basis from every part of this world. Now, what is happening here is that when you are preparing a prospectus, it is the knowledge that matters and not the information. Why? If you have to write a prospectus about a company, inherently you should have known about the company, you should have studied about the company, you should know what the company is all about. You cannot just go further and say that, sir, this is the company, this is the factor, I just wrote it. You cannot claim any sort of innocence once the prospectus is published. So that is why I claim here saying that it was issued without my knowledge, which means without my knowing, without my intention, without my involvement at all in any terms. At that point of time, yes, you are not liable because it was without your knowledge, which means it was not even in your purview at all. Next one. After the issue of prospectus before allotment, I became aware that the prospectus was untrue, withdrew the consent. Now, this is even more getting into the factor. I have made the prospectus, but then I raise up my hand and I clearly say, sorry, sir, I had made a mistake. There are some statements which are untrue. So I am now aware of the consequences even before it hits the public and I start taking money from them. I start allocating the shares. So I go ahead and I claim before itself saying that, sir, I am not getting involved anymore. Let us stop the process then and there. So that means to say that I will claim my innocence. I don't want to become liable for any kind of actions like this. Now, why that is also important here is that many a times what happens is that people would have just claimed in their way, in their walk of life about saying that, yes, these are the factors, these are the things, and I have taken the allotment, and then one fine morning, there would be an investor standing at the door of the company saying that, sir, whatever you said is wrong. You are now responsible for the loss of my money. So I don't want that to come. So I go back, make a public notice on the withdrawal, and I say that, sir, I am completely unaware of the situation. Let me withdraw back. Sorry for the wrong information that has been provided. In that case, yes, you can claim an innocence. Next one. As regards the untrue statement, the experts believe that on the grounds of that statement was true, correct, and fair representation. Now, what is going to happen here is that the public might have misunderstood you, which is quite common. Why? Because when you read a prospectus, there will be 1,000 meanings about a word. There might be 1,000 factors under which it might be assumed and it might be interpreted altogether. But that is not the intention of you. The experts of the company, experts of the field believe that no, there was no intention. Whatever that was stated is perfect, it's clear, and it is not any form of cheating at all. Then you are not liable for any mistake. Why this I am trying to tell is that there are many words like, for example, project, concern, institution, holding, parental company. There might be words like this which might be seen in the prospectus. People will get confused with these kind of words because investors feel that what is a concern, what is an institution, what is a firm, what is a partnership, then what is a holding. There might be words which might not be known to the public, but your intention in writing the prospectus was not wrong. Your intention in putting the financial records was not wrong. You have done your job perfectly, clearly, very well. So that is why we say that these prospectus, unless and until you are under these terms and conditions, no need to worry, sir. You are very much in the safeguard position. Moving forward, civil liability for, again, when will this comes into it? Expert civil liability is limited to the opinion given by him in the prospectus. Now, it's only a very, very limited matter. He is not considered to be a person who is authorized to issue the prospectus. Now, the expert would not be held liable if he proves any of this following. Now, let's try to understand who is this expert first, and then we will come into the civil liability again. Expert is a person who knows about the company, who knows about the situation, who knows about all the factors that are governing that. But then, expert is not the person who has been authorized to issue the prospectus. He is not the authority. He is only a person who is going to give his expert opinion about the company, about the issues altogether. So that's why I would say that he is trying to provide an expert opinion. So in this case, the expert would not be held liable if he proves any of the following. Then what are those following? That he had given the consent for the inclusion of his opinion. Sir, I have given my ideology in the prospectus, but he withdrew the consent before the prospectus was filed with registration. Now, as an expert, I would have believed, I would have known certain matters. I know certain amount of knowledge about the company. I have certain ideas. So I went ahead and told the company, why don't you include my idea like this? This is what I'm trying to say all about. But then after some time, I withdrew my consent. I withdrew my ideologies, withdrew my words saying that, sorry, I'm taking it back before the registration of the prospectus went ahead, which means I am not sure what has happened here. So that's why I'm going to withdraw my consent altogether. In that case, I am not held for a civil liability. The second thing, after the registration of the prospectus and before allotment, suppose if there are any untrue opinion and then I withdraw it with a reasonable public notice, then automatically I am not held liable. Now, why is this? Because many a times, the guilt feeling of doing something wrong and making the people get affected out of it is definitely a very, very big concern that comes into picture. Many people feel that, sir, I have made a mistake, but I'm really shy, I'm really afraid of going before the public and raising my hands and asking a sorry. But let us understand that if you have the guts, if you have the factors of going forward, the strength of going forward and telling the public even before a major mistake that can be averted, that can be done, then automatically you will be getting a better stand for yourself. So what the expert will also do is that, suppose in case it has been done, the mistake has been done, but before the allotment of shares that is going to happen, the share capital allotment is going to happen, I go and I appeal before the public with a notice saying that sorry for whatever I have done, there is something which is untrue, let me not go with it, then automatically that gets withdrawn. You will not be held for the civil liability at all. So that is why I say that this is the opportunity for people not to take this kind of risk or any chances. Finally, that he believed that he is up to the date of allotment, the statement was true to the best of his competence. Now, whatever I have said is truth. I'm not going to go back on my words. Now, if it's going to be proved wrong or somewhere it is going to be proved that there is a mistake, but still I believe that under the best of my knowledge, under the truth, under the best of my knowledge, my ability, whatever statement I have told is correct. So I am going with my competence, with my ideology altogether. I am not trying to go further and explain it to anybody else, but this is the factor which I believe in terms of understanding. So that is why it becomes very, very important for the civil liability process. Next one, of the directors. The director's civil liability expands to the whole of the issues because they are the persons who have authorized for the issue, and the director shall be responsible even for the matters that has been done by the expert. A director can avoid if he can prove the following. Now, before going into what he is going to prove, let us first understand the role of a director here clearly. Director is a person who is either full-time or part-time nominated by the company, and there are shares allocated to him. Plus, the major factor is that he is the person with the others who is going to authorize for the prospectus and who is going to go forward in terms of the issue. So in that sense, the authority and responsibility of a director will be definitely questioned if there is going to be a mistake in future. So that's why we are going to bring in here. But then a director can also prove that he is innocent, he is not directly involved in any kind of crime or any kind of thing, only if the director had withdrawn his consent before becoming a director and the prospectus was issued without his authority. So I withdraw my consent saying that, sir, before even becoming a director and the prospectus getting issued without my knowledge, then I will go ahead and say I am not responsible at all. That was done by the company side, not by my side. Next one, that the prospectus was issued without his knowledge, and when he became aware, when I came to know that it has happened, the issuance of prospectus, he gave a reasonable public notice. So he goes back and he goes to the public and he says very clearly, sorry for whatever happened because I have not done it with any intention or with any purpose. This has been done without my knowledge, without my awareness. So I claim innocence here. I claim that I have not done anything, and I am going back to the public with a notice factor, with a reasonable amount, saying that this is what has happened altogether. Now, moving forward, the civil liabilities of directors also come to the factor that he became aware of the untrue statement. Yes, I know what has happened here, so I'm going to be very, very careful on the issuance of prospectus. And he gave a reasonable public notice, and the statement of a true copy or the true extract that has been made by the expert, and the directors believe that he had sufficient knowledge of what is happening. That is the ability to express the opinion. So the person will now come back and tell very, very clearly, yes, sir, I knew what was happening under this competence. So I'm not going to cheat you. I'm not going to take you for a ride. Rather, I'm going to come and tell you very clearly that this is what has been happening altogether, sir. So please believe me that whatever I'm doing is right. And the statement of true copy on extract of any public official document, so which has been provided with evidence saying that they have not cheated the public. Now, criminal liability. Now, let's get serious about the misstatement altogether. When the prospectus includes any untrue statement, every person who signed or authorized the prospectus shall be punishable with an imprisonment term which might extend up to 2 years, with a fine or an extension of 10,000 rupees or both. Now, this becomes serious. After doing all these mistakes, after doing all those untrue statements, misstatements and all those factors, and you sign on the prospectus, now every person who's involved in this activity will definitely be questioned by the government, which will include imprisonment, plus 10,000 rupees fine. The imprisonment can go up to 2 years. So that's where the company law and the registrar of companies say very, very clearly, sir, please understand before signing the prospectus. Do not go ahead, sign the prospectus and then say, I'm going to claim innocence. I do not know. Once it has been signed, once it has been launched in the public, we will have no control about the prospectus at all. So that is where you have to be very, very clear that once it is signed, once it is approved, it will go into a criminal liability, which is a serious offense altogether. With this, I come to the end of this session. I believe that all the information provided in this session is of a high resource and importance to you. In the upcoming sessions, we will be talking about the other factors of company law and how the Companies Act is actually helping in terms of development of the companies. Until then, stay tuned, stay blessed, and stay enlightened forever. Thank you once again for joining me on this wonderful day.